Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Win, Lose, or Draw: A Decade of Pharma Antitrust Since FTC versus Actavis. In 2013, the United States Supreme Court decided that reverse payment settlement agreements, so-called pay-for-delay agreements, are not immune from antitrust scrutiny. Rejecting at least two other potential legal standards, the court chose the rule of reason approach to determine whether such agreements violate antitrust law. The 5-3 decision in the case has been interpreted as a victory by those in favor of more aggressive scrutiny of business activities for evidence of anti-competitive effects, and as a defeat for those who believe that this scrutiny has the potential to damage incentives and reduce innovation in critical fields such as life sciences and technology. 10 years after Actavis, the implications of the case have been far-reaching for practitioners and for pharma companies, but not necessarily in ways originally predicted. Today, we're happy to welcome to our Curious Amalgam two guests who've spent the past 10 years in the trenches of delayed generic entry matters, who bring a unique historical and substantive perspective to these debates. But first, let me welcome my co-host, Aaron Yeater. Hi, Aaron.
Hi, Alicia. How are you?
Fine, thanks. Would you like to introduce our guests and kick off the discussion?
It would be my pleasure. Thanks, Alicia. So our guests today are Kristen O'Shaughnessy. Kristen is a partner in the antitrust practice of White & Case in New York City. She has a broad array of antitrust litigation experience, but with a particular focus on issues at the intersection of intellectual property and competition, which situates her very well for today's discussion. And she also works with an array of global life sciences companies on those matters. And she's joined by her colleague in the same office of White & Case, Dan Grossbaum. Dan's a litigator with a growing expertise in issues concerning entry of generic competition in pharma markets, as well as issues related to class certification for direct and indirect purchaser classes. Thanks, Dan, and thanks, Kristen, for joining us today.
Happy to be here.
So I'm happy to kick things off. It was a decade ago that the Supreme Court ruled in this case, and we don't need to go through all the gory details, but can somebody start by telling us a little bit about how we got here? How did this case in particular end up at the Supreme Court? Kristen, do you want to take it?
Sure. Happy to jump in. Thanks for having us. And just a quick disclaimer at the top of the show. Dan and I and our colleagues at White & Case do quite a lot of these cases, so anything we say today shouldn't be attributed to our firm or any of our clients. But now that that's out of the way, how did the Actavis case get to the Supreme Court? So back in 2009, the Federal Trade Commission sued a brand and multiple generic pharmaceutical manufacturers, alleging that the way in which they had settled patent litigation previously was anti-competitive. So what had happened before that, several years earlier, was that the brand had sued the generics for patent infringement. The generics, in turn, claimed that the brand's patent was invalid. And ultimately, that patent litigation settled. Under that settlement agreement, the generics received a license to enter the market before the brand's patent expired, and they dropped their challenge to the brand's patents. The brand, in return, provided payments to those generics. So that's the backdrop. So in the FTC's case, the FTC claimed that these so-called reverse payment settlement agreements, that those were anti-competitive because the brand was sharing its patent-protected monopoly profits in exchange for the generics agreement not to compete. The defendants argued, well, no, that type of agreement is not anti-competitive because, well, patents confer a lawful monopoly, and it allows patent holders to exclude competition. And the settlement agreements didn't exclude any competition beyond the life of the brand's patent. the district court agreed with the defendants and dismissed the FTC's case at the motion to dismiss phase. It went up to the 11th Circuit, which affirmed the dismissal. And the 11th Circuit found that reverse payment settlements are immune to antitrust attack as long as any anti-competitive effects of the agreements fall within the scope of the patent. And that's become known as the scope of the patent test. So that was the 11th Circuit. The Federal Circuit and the Second Circuit had reached similar conclusions about the scope of the patent, but the Third Circuit had come to a different conclusion and had held that reverse payment settlement agreements are presumptively anti-competitive. So the Supreme Court took this case up in order to resolve the circuit split and to assess how do you apply the antitrust laws to settlements in the pharmaceutical patent litigation context.
For folks who followed this area, how important is the regulatory environment? I imagine that folks are familiar with Hatch-Waxman, but may not understand exactly how it sets the context here. Is there important information in that, or was this just a problem that pre-existed that regulatory environment?
Yeah, so I do think it's important to understand the regulatory context here because it does make these cases a little bit different from other types of antitrust cases. So the patent litigation that was at issue in Actavis is, as you referred to, it's a specific kind of litigation that is particular to the pharmaceutical industry. And that kind of patent litigation is typically called Hatch-Waxman litigation, which I think won't come as a surprise to anyone to know is a construct of the Hatch-Waxman Act. We could probably fill an entire podcast on all of the intricacies of the Hatch-Waxman Act, but we won't do that today.
Good idea.
Without getting too much into the weeds, I think what's important for us to know or think about for our purposes today are that the Hatch-Waxman Act allows generic companies to challenge brand patents before they ever enter the market. And if they do that, under the Hatch-Waxman Act, it's considered an artificial act of infringement. And then the brand can sue the patent for patent infringement, even though the generic hasn't even come to market yet. And so due to this specific sort of regulatory construct here, what that means is in Hatch-Waxman litigation cases, although the generic is technically the defendant, they aren't actually exposed to damages while they're challenging the brand's patents. So while the brand risks potentially losing patent protection on its pharmaceutical products that may have cost hundreds of millions or billions of dollars to develop, typically the generic doesn't have very much to lose. Essentially, they're usually only risking the cost of litigation. So I think that's sort of a unique context that it's important to remember as you're thinking about how these reverse payment cases arise.
I've got a question. It's been a long time since I've read the decision, and I'm not normally practicing a lot in this area. I wonder if one of you can just maybe give us the highlights of the majority's decision and maybe a few key points that the dissent made, because this was, in fact, a 5-3 decision.
I can jump in there with the majority, and then I'll let Kristen kind of talk about the dissent a little bit. But so Justice Breyer's majority really starts from analyzing that these sorts of agreements are unique, and it's really a product of the regulatory landscape that Kristen described, that you have this aspect of generics who actually aren't exposed to damages, but you have compensation flowing to them nonetheless. Justice Breyer really looked at, well, what sorts of considerations should he be considering? And he looked both to patent and antitrust considerations, which seemed only natural. The scope of the patent really was focused on patent considerations and finding that those would trump antitrust concerns, and the per se or quick look test being put forward was focused mostly on the antitrust considerations. And so Justice Breyer looked at both. He looked at the Supreme Court's prior precedents and just determined that neither set of principles should trump the other. ultimately, he concluded that the agreements really should be analyzed under the rule of reason framework. And perhaps most famously, he instructed that to determine whether a reverse payment agreement was unlawful, courts should be evaluating whether the agreements contain what he called a large and unexplained payment, or a large and unjustified payment from the brand patent holder to the generic, because the existence of that sort of payment, one that's large and unexplained, could signal that the brand was really viewing its patent as weak, and that it was paying the generic to stay out of the market rather than choose to litigate the case. So it really seemed like Justice Breyer's opinion was less concerned about the fact that there was compensation flowing, or even necessarily with what direction it was flowing, but more why there was compensation. And if the compensation was there to protect a weak patent, one that was going to be or potentially going to be invalidated, that was going to present antitrust issues. And so Justice Breyer provided a few different, aspects that courts and litigants could consider for determining what other things could the payment be for. So he pointed out things like saved litigation costs, like Kristen mentioned earlier. He mentioned things like compensation for other services that are being provided, and then he left it kind of open-ended on other justifications. And I guess the second kind of major thing that came out of Justice Breyer's decision was that the rule of reason framework was supposed to be applied as it is in all other cases. As some of the listeners may know, the rule of reason is kind of a very standard, commonly used framework for analyzing antitrust issues. And so it really wasn't intended to be a whole new standard. It really was to apply the ordinary rule of reason framework to this sort of unique circumstance.
Chief Justice Roberts issued a dissent that was joined by Justice Scalia and Justice Thomas. And I think a couple of the major takeaways from the dissent that are noteworthy are, first of all, Chief Justice Roberts advocated vigorously for the scope of the patent test, and he really disagreed with the majority's decision to evaluate reverse payment settlements under an antitrust framework. Because, as he said, a reverse payment settlement is only even potentially anti-competitive if the patent is invalid. And so in order to get there, you would really have to kind of ignore the fact that the brand has a valid patent in the first place that allows it to exclude competition. And so he voiced a concern that he didn't understand how the majority could conclude that it wouldn't normally be necessary to litigate patent validity in order to answer the antitrust question, when patent validity should be an absolute defense. And he predicted that that's an argument that brand manufacturers would likely make. And I think he was right about that. And I think courts really have grappled with, well, how do you resolve these cases without relitigating patent validity? Because a valid patent would allow a company to exclude competitors. Second, and I think relatedly, Justice Breyer's opinion has been criticized by some as being in some ways theoretical. And Chief Justice Roberts, on the other hand, I think was really concerned with practicality and administrability. So how would this framework affect businesses? Would it dampen the ability of parties to settle litigation? Would it disincentivize litigation? Is it unnecessarily removing options parties have for exchanging value when negotiating settlements? And he really reiterated the importance of having clear rules in antitrust. And I think he was concerned that courts and parties were going to struggle with understanding how a reverse payment analysis would work in practice. I think one thing that's really noteworthy about the opinion is Justice Breyer, in his portion of the opinion, said he'd leave it to the district courts to figure out the details of how to put this framework into action. And in response, Chief Justice Roberts said, well, good luck to the district courts. And I think when he said that, he was correctly anticipating what a tall order it would be to sort out how the Actavis opinion would actually function among the lower courts.
So that segues nicely, I think, into the question of who won. And part of the distinction, I think, that you're even pointing to is that it isn't even clear which voice of the court has become most important in the years since. But I'm curious, Dan, if you have a sense of who we can describe as having won the decision. The FTC cheered it at the time. Actavis seemed satisfied with aspects of it at the time. Is it even Justice Breyer's decision that they are celebrating, or Chief Justice Roberts' dissent that they are celebrating? Who are the winners and losers here?
Yeah, I think it's really hard to say that anybody won, but I think it's equally hard to say that anybody lost. So, the FTC was pushing for the presumptive illegality standard, which would have made it much easier for them to prove that these sorts of agreements were anti-competitive and therefore likely succeed on the merits. And we haven't seen in the last 10 years any jury verdicts where the plaintiff has succeeded. And so I think it's hard in that sense. The FTC's inability to persuade the court to adopt that presumptive illegality standard is a loss. But equally, the defendants were pushing for presumptive legality, and we've seen a lot of these cases filed in the last 10 years. And so equally, that's a loss for the defendants. On the flip side, the FTC is still able to challenge these agreements, so they did retain that right, and that's a win. But equally, the defendants have the ability to justify these agreements in a way they probably wouldn't have under a presumptive illegality standard. So that's a win on their side. So I think everybody got a little bit of something. I don't think everybody got what they wanted, but it's really more of a sidestep than I think of anything of a win or loss.
So apart from the winners and losers, to the extent that the Actavis decision sets forth any kind of framework for deciding cases that came after it, have you seen examples where courts have attempted to reason their way through a case using the framework that's spelled out in the majority decision?
Yeah, I mean, I think, Justice Breyer's opinion certainly provided some guidelines for a framework for district courts to use and other courts to use. For example, we discussed earlier, he provided, the payment must be large and unjustified really to bring about sort of antitrust concerns. And he instructed that the rule of reason should apply. But like Kristen mentioned, he left it to the lower courts to really figure out how to apply that framework. And I think that's resulted in a lot of different sorts of opinions in terms of the sorts of frameworks. I think courts are really still in the experimental stage, even though we're 10 years later, on exactly how's the most efficient and the best way and most faithful way to the majority's opinion to structure the rule of reason, to incorporate all of these considerations and then really come to a manageable litigation. I think all of those things being juggled in the air at the same time has been really difficult, and something that we've seen kind of courts, litigants, and juries, I think, even struggle to handle as these cases have progressed.
Kristen, Dan referenced the fact that no plaintiff has succeeded at trial, but also that the decision seems perhaps to have created an environment in which a lot of cases have been filed. And I assume as a result, a lot of cases have gone to trial. So what do we learn from the trials? How has this changed the trials, or how are the trials playing out? And is there information there about what Actavis's actual effect has been?
I certainly think what we've seen is a lot of cases have been filed in the reverse payment space in the last 10 years. Most of the cases have been brought by private plaintiffs rather than by the FTC. So there are some differences in the analysis that the plaintiffs have to undertake and what they have to prove in those cases. As Dan has mentioned, though, of the dozens of cases that have been filed in the reverse payment space, only 3 of them have gone through to a jury verdict. And all 3 of those verdicts were returned for defendants. So, it's actually quite a small proportion of cases that have been filed have actually made it all the way to the end. And no cases have been appealed back up to the Supreme Court. So I think maybe that's something that's interesting to note there. I think you can infer at the trial level that the defendants have a perfect record at trial, and I think it's a good indicator that the defendants have a clear trial advantage. But on the other hand, with so many cases that are filed, the courts are really hesitant to dismiss these cases in full at either the motion to dismiss or summary judgment stage. And so you have a lot of these cases that go through discovery. And Chief Justice Roberts pointed out in his dissent that discovery is famously burdensome in antitrust cases. And so you've got damages in these reverse payment cases quite often are very significant. And so even if defendant pharmaceutical companies have an advantage at trial, they more often than not face high risk exposure and high litigation costs to get to trial. And so, I think when you're thinking about who has the advantage, I think both sides have challenges that they face in these cases. And so I don't think either side has a clear advantage, but I do think what we've seen is that it is very rare for a case to get all the way to the end through trial.
I think one outgrowth of that, or at least the way into the Actavis opinion, is that when you read Justice Breyer's majority opinion in Actavis, it kind of reads as the first step in kind of a multi-chap novel. That almost Justice Breyer almost seemed like he expected another case after more development, right? Go lower courts, go forward, structure the rule of reason, play around with different ideas, and then we'll take another case later on with those ideas more fully baked at the lower courts and provide additional guidance. But I think for a variety of reasons, one of which is that the cases have not gone to trial and they have not, gone up to the appellate courts at the same speed and then up to the Supreme Court. There hasn't been that second decision yet. The only case to go up to the Supreme Court has been Actavis, and so I think that's one of the other challenges. As the lower courts and parties are working through it, is that it just hasn't made its way back up for what seems like should have been a second opinion or maybe third opinion on these sorts of issues.
Now, looking ahead into the future, how about the next 10 years or 20 years or 30 years? What do you think will be the effect of the Actavis decision going forward and perhaps in other areas, other industries? What do you think will be some principles that will be more refined?
Well, I think there's a lot of areas that still need to be hammered out by the district courts. 10 years on, there are still a lot of issues that are hotly contested by parties in reverse payment cases. And for the most part, there's very little consensus. There are a few areas that I think there's consensus in. So for example, one of the issues that's been litigated is when you're thinking about reverse payments, what can constitute a payment? There is consensus that the payment doesn't have to be cash. It can be something else of value that's transferred from the brand to the generic. But we don't know exactly where the boundaries of that are. So one thing that's been, I think, is a hot issue right now is, well, can most favored nation clauses in a settlement agreement, can that be considered a payment? Another area that is hotly litigated in these cases that I think is still unsettled in some ways is when you're thinking about, do you have a large and unexplained payment? How do you determine whether something is large? So the Supreme Court said, well, the size of a payment can indicate the brand's concern about losing its patent. So there's a reasonable argument that the payment should be compared to the size of the patent protected profits. So defendants often make that argument. But there's another argument that plaintiffs often make, which is, well, a payment can be large if it's large in relation to litigation costs. So those are two very different benchmarks, and you can reach very different conclusions depending on what you're using as a benchmark for large. I think that's another area that really still needs to be explored and still needs to reach consensus in the courts. Justice Roberts, in his dissent, noted, well, district courts are going to have to resolve the question about what was motivating the brand to make a reverse payment. But how do you do that when what's motivating the brand to settle quite often is going to be privileged? How do you actually analyze the brand's motivation, whether they were making a payment because they were uncertain about the strength of their patent, or whether they were making the payment for other legitimate reasons, right? That is something that we really have seen courts and litigants go toe-to-toe on. How do you navigate that? For example, can an expert's post hoc opinion about what an objective brand would think about its patent strength, can that be a substitute for what the brand subjectively thought about its patent strength? There's a lot of really complex issues that are being litigated in these cases, and I think we're going to see them continue in the future for years. And we've only really scratched the surface today about the various issues that have come up. But as Dan noted, there really are very few cases in the reverse payment space that have gone up on appeal. And if we do see a case reach back up to the Supreme Court, it's noteworthy that the Supreme Court has changed a lot in the last 10 years. So of the 5 justices in the majority, 3 of them aren't on the bench anymore. So the makeup of the court is really different than it was. And so if a reverse payment case was revisited by the court, I think it'd be really interesting to see what the court would do with it.
Well, it sounds like there will be a lot of things for you and Dan to work on in the years to come. It's good that you're both young and energetic. As we reach the end of this episode, we're not going to let you go just yet. We like to get to know all of our guests a little bit better as people. So I want to ask you, each of you, to tell us a little bit of something interesting about yourself that we wouldn't know if we only knew you professionally. And I'm going to ask Kristen to answer first.
Something that people might not know about me is that I have lived on 4 continents. Something that people probably do know about me is that I love to travel, and I try to visit at least one new country every year. And if you work in my office, you also probably know that I have a giant map of the world on my wall with pins marking places I've visited and lived.
Have you been to Antarctic? I mean, have you got that one out of your way yet? Or is that, what are the 3 that you haven't visited yet?
Antarctica is the only continent that I have not visited.
Oh, so there's 7 continents, right? So you visited 6, I think. Okay, very good.
How about
you?
Lived on 4.
You've lived on 4, but you visited 6 out of 7. All right, well, get down to the South Pole this summer. Dan, how about you?
It won't be there for much longer, I think, is Alicia's point.
Yeah, while it's still there.
So something interesting about me. So in my former life, before I went to law school, I actually worked for a private investigating firm that specialized in on-site audits of sports and entertainment venues across the U.S. And so in that job, I was actually often tasked with testing the stadium security, which included many attempts to sneak myself into stadiums in ways I will not describe here, but sneak in around security, sometimes successfully, sometimes not successfully. And I did that for about 7 years. And so I got to see some really cool concerts and some really cool sporting events. And I also got to have a little bit of fun while doing it.
Okay, well, I hope you weren't manhandled too badly on the times that you got caught.
You never knew what you were going to get if you got caught. So the whole goal was don't get caught.
Oh, my goodness. All right. Well, thank you for those very interesting answers. And now for the final segment of our episode, we're going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat.
The rules of the game could not be more simple. Aaron will draw a random question from our virtual hat and read it out loud. Aaron, please read the question.
Okay, here we go. The question is, if you could choose free front row tickets for any performing arts show, festival, or sporting event in the world, what would you choose?
Well, I'll go first. I have always wanted to go to the World Cup. So I've never been to a World Cup game, but I would love to go.
Okay. How about Daniel? You're a professional stadium crasher.
Yeah. I have been to the front row of certain events, maybe, but we won't disclose how. But no, I think if I really was able to go, I think it would be something similar to Kristen, but it would probably be the front row of the Super Bowl, specifically with the New York Giants playing in it. So that would probably be my number one.
Okay, we have sporty people here. Thank you to our guests, Dan Grossbaum and Kristen O'Shaughnessy. Listeners can find out more information about the topic of today's episode on the webpage. Thanks for listening.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.